Okay. I know what you mean. Our guy in our group, we're having a home run party sometimes. He's from Puerto Rico, and he was like, oh, we got it. It's like, home run party today. Come here. Yeah. Our mom's not gonna
student government communicators. Also, like each like school in Florida is basically. I don't even have a Twitter on my own. Okay. I don't have separate accounts for things.
She's so aggressive.
Different to whoever's the president of the club. I'm not the president of any club yet. You should run for your crown. I was in Susan when I got voted on. We're on the same bus. You'll see.
Oh my god, can you not remind me?
No, so like, us three sit with each other. Oh wait, shoot. We are. So you'll hear me.
It's the funniest thing. You came out of nowhere, we were all
I have very good ones. Wait, did Dylan record it? Wait, is that Dylan? Is Dylan? No, I like Cardi B. I want them to because they rule the industry.
that will never happen.
It won't, but I want them to. I mean, they did on Motorsport. The only reason why Motorsport is even kind of good soft. No. I like Cardi's personality. I think they're very full and their voice is very auto-tunable. I think that's not a real talent. They're an appealing figure and their voice is very auto-tunable. That's really appealing. That's the only feature. Is your voice auto-tunable? Should I give you something that's write songs for you and have you sing them with your voice? Would you say that my figure is good enough? saying that you need to either, if you want to be a famous musician, you need to either be incredibly talented or incredibly talented.
I'd much rather be confident.
Okay, so you need to do stupid stuff that will make some people think you're completely insane, but some people will still love you. No, not all of them. Some of them are, no, I'm talking about the modern music industry, rap stuff. Like, you either need to be incredibly controversial or just everybody listens to you. One or the other. I know, but I'm talking about the modern. I like the one person whose career started in 2013. There's one person I like who, there's one person I like who got his career started in 2013. Very close. He's very talented. But you don't like music? So that's like people. I think that's like the test love. It's like classic rock and like 90s rock. Rolling Stones, Led Zeppelin,
Oh yeah, that's my fault.
Good.
It just came like that.
I know. It's HP. That's cool. I like the red underneath.
Acting Director Albence, thank you for your patience and your willingness to stay until 4 o'clock, given the votes that we had. We appreciate it. Today we welcome Matthew Albence, the Acting Director of U.S. Immigration and Customs Enforcement. Thank you for being here this afternoon. As we continue to monitor the challenging situation on the southern border, we look forward to hearing your perspective on ICE's operational and funding priorities and requirements. As chair of this subcommittee, I am committed to ensuring the integrity of our borders and strengthening our immigration system. But I am equally committed to making sure we do so according to all our laws and in a way that exemplifies our American values. In particular, we must ensure that in accordance with our laws and values, those fleeing violence and persecution have meaningful opportunities to seek asylum. We must get this balance right, and I believe that we can if we work together. It is a false choice to believe that more migrants need to be unnecessarily detained and that cruel and exclusionary immigration laws need to be enacted in order to increase security in our country. Our own Constitution, federal law, and several international agreements serve as the foundation for the rights and protections I believe need to be embodied in our efforts to address the humanitarian crises we are currently experiencing. Unfortunately, the rhetoric and the policies of this administration have made achieving that balance more difficult, and by all indications have exacerbated our challenges at the border. We must also be mindful of the resource limitations that we face. There is likely no area of our bill where we have sufficient resources to fully address known requirements. For instance, we are barely cracked the surface of what the Coast Guard truly needs to address the flow of illegal drugs in the transit zone or to protect our sovereign interests in the Arctic. Detention is a very expensive option that should be reserved for cases where public safety or flight risk is a valid concern. When public safety is not a concern, I should use alternatives to detention. When used as intended, with appropriate case management, alternatives to detention have proven to be effective in mitigating flight risk and improving compliance with immigration court requirements. For those whose detention is appropriate, I remain seriously concerned about substandard conditions at ICE detention facilities. In addition to what I have personally witnessed, we continue to get alerts from the media, the Office of the Inspector General, the Government Accountability Office, and advocacy organizations about detention facilities that do not meet ICE's minimum standards but are nevertheless allowed to continue operating. Preventing these inhumane conditions can only be achieved if ICE leadership makes clear that anything less is unacceptable and will have consequences. I will continue to work with ICE to ensure that this happens. On a more positive note, I want to highlight the good work ICE does in areas such as combating human trafficking, human smuggling, child exploitation, and the smuggling of fentanyl and other opioids. In the fiscal year 2019 appropriation, the subcommittee provided additional resources to Homeland Security investigation for these efforts. This is a great example of a mission where we have worked together to accomplish shared goals, and we have sustained these efforts in our fiscal year 2020 bill. Lastly, I want to follow up on the letter I sent you on July 12th about increased interior enforcement operations. I requested that you submit for the record today some of ICE's written policies and procedures, which I described in that letter. This kind of transparency is very important for us to better understand how ICE's leadership expects its frontline officers and agents to operate. I understand that you have submitted documents in response, so I thank you for that, and I look forward to reviewing them and will follow up accordingly. Before I turn to the director for a summary of his written statement, the text of which will be included in the hearing record, let me first recognize our distinguished ranking member, Mr. Fleshman, for any remarks he wishes to make.
Thank you, Madam Chair. I'm going to keep my remarks very brief, as I know we've been delayed by votes. Welcome, Director Albence. Thank you for your time and your testimony before the subcommittee today. There's been a lot of change in leadership positions at the department in recent months, and it is reassuring to me to have an acting director with your years, really decades, of experience at the helm. Thank you for assuming the awesome responsibility of leading this law enforcement and Homeland Security agency. I very much appreciated the other day with you and your most able staff, the visit and the update. It helped me to understand exactly where we are and where we're going. Again, I thank you for your hard work. I look forward to working with you and look forward to your testimony today, sir. Madam Chair, I yield back.
The order in which members will be called for questioning will be based on the seniority of those present when the hearing was called to order, alternating between majority and minority members. Also, to ensure everyone has ample opportunity to ask questions, I ask that each member stay within the allotted 5 minutes per round. Director, please begin your statement.
Good afternoon, Chairwoman Roybal-Allard, Ranking Member Fleischman, and distinguished members of the subcommittee. As you are aware, the United States is currently facing an unprecedented national security and humanitarian crisis at our southwest border. Over the past year, the number of aliens apprehended at or near the southwest border has increased significantly. Today, however, I am here to address other parts of the immigration system that remain in desperate need of resources and funding, as well as to highlight the need for legislation that would help put an end to the current border crisis once and for all. The fact is, the majority of the aliens encountered at or near the border are released into the interior of the United States for removal proceedings, and the immigration courts currently have a backlog of more than 900,000 cases and growing. The dedicated officers and agents of ICE are responsible for managing these cases, as well as those of the more than 3 million aliens currently on ICE's docket. Many aliens do not appear for removal proceedings, violating the terms of their release, including the terms of the Alternatives to Detention program, and fail to appear for their hearings or comply with removal orders. The result is that the border crisis has become a national crisis, which requires a strong interior enforcement component that lends certainty to lawfully issued orders by immigration judges. The reality is, if our immigration laws are only enforced at the border, and you fail to provide adequate resources to ensure that those who have entered illegally proceed through the immigration process, and if ordered removed, are actually removed, the entire system will break down. This failure will continue to serve as a magnet for additional aliens to illegally enter the country, and you will never have a secure border. With this in mind, I come to ask for your assistance in providing ICE the funding it desperately needs to address not only the ongoing humanitarian crisis, but also the concurrent national security and public safety crises. While ICE's immigration enforcement is focused on the interior, the current situation at our border directly impacts this agency and its resource requirements. CBP's 780,633 encounters include more than 390,000 members of family units and 63,000 unaccompanied alien children. This represents 63% of all southwest border encounters in FY 2019 year to date. Notably, in the last few months, ICE alone has been forced to release more than 215,000 members of family units into the interior of the United States due to the Flores Settlement Agreement. ICE's resources have been overburdened by the record numbers of CBP apprehensions at the southwest border, and Congress's repeated failure to fund ICE detention and transportation requirements at ICE requested levels. ICE is currently detaining over 53,000 single adults, and there are approximately 8,000 single adults in CBP custody awaiting processing or transfer to ICE. Due to its very limited detention capacity, ICE must generally reserve its detention space for those who require congressionally mandated detention, along with those who pose a national security, public safety, or flight risk. However, based on increased enforcement activity on the border, additional ICE detention capacity and transportation funding is urgently needed. To ensure the national security and public safety of the United States and the faithful execution of the immigration laws passed by Congress, ICE officers may conduct targeted enforcement actions against any removable alien who is present in violation of immigration law. Despite what is often sensationally misreported, these are not indiscriminate raids or sweeps. Instead, ICE's operations are carefully planned based on person-specific, intelligence-driven leads, focusing on those who represent a public safety threat, as well as those who have received a lawfully issued order of removal from an immigration judge. Approximately 90% of EROs, administrative arrests in the interior of this country, are of aliens that have prior criminal convictions, face pending criminal charges, are immigration fugitives, or who have previously been removed from the country and have illegally reentered, the latter of which is a federal felony that ICE prosecutes extensively. However, the crisis on the border has negatively impacted ICE's interior enforcement mission, and thus the public safety of our communities. Resources dedicated to removing dangerous criminals from the streets have been redeployed to manage the increased workload stemming from the border surge, resulting in an over 14% decrease in criminal alien arrests this fiscal year. Additionally, ICE has reassigned members of fugitive operations teams to manage detained dockets or help respond to the border crisis. The failure of Congress to increase funding for fugitive operations over the course of the last decade has created a tremendous strain on ICE's ability to effectuate arrests of specific aliens who have failed to comply with removal orders or with release conditions, including those who have absconded while on ATD. While Congress has sought to increase funding for ATD, it has failed to fund the necessary resources that make the program effective. Without sufficient numbers of fugitive operations officers to search for and arrest aliens who fail to comply with ATD, as well as sufficient detention space for those aliens to be detained once they are located and arrested, ATD will continue to offer very little benefit for its cost. Additional resources are also requested in FY20 to ensure that ICE's Office of the Principal Legal Advisor is able to carry out statutory responsibility to prosecute administrative immigration cases before the immigration courts. While Congress has increased the number of funded DOJ immigration judges and support positions during recent budget cycles, OPLA funding has not kept pace, thereby exacerbating the backlog. More critically, and most critically, I would like to highlight legislative changes that are urgently needed. To be clear, the FY20 budget request only provides the necessary funding and resources for ICE to address the symptoms of the crisis. It does not, nor can any amount of resources, solve the problem. Legislative changes are the only viable option to swiftly put an end to the current crisis, reducing the victimization of migrants looking for a better life and starving the cartels and transnational criminal organizations of a major segment of their illicit enterprises. Absent these changes, current laws will continue to be exploited, and the pull factors they create will only result in more illegal immigration and worsen the humanitarian crisis. We ask you to, 1, terminate the Flores settlement agreement and clarify the government's detention authority with respect to alien minors. Amend the Trafficking Victims Protection Reauthorization Act to provide for the prompt repatriation of all UAC who are not victims of human trafficking and do not express fear of return to their home country, and address the credible fear standard. The current standard has proved to be ineffective in screening out those with fraudulent, frivolous, or legally insufficient claims, and has further strained our overwhelmed immigration system. By requiring the release of family units before the conclusion of immigration proceedings, seemingly well-intentioned court rulings and legislation are being exploited by transnational criminal organizations and human smugglers. These despicable smugglers have created an entire illicit industry with untold millions of dollars being made through the sale, rental, and recycling of children utilized by unscrupulous adults to pose as family units. To fight this activity, Homeland Security Investigations has reassigned hundreds of special agents and intel analysts to Border Patrol facilities to ferret out fraudulent family units and UAC. These same loopholes also encourage further illegal immigration, as the record numbers indicate. These are not talking points. These are facts based on my over 25 years of law enforcement experience, and they represent the major challenges currently faced by ICE. Every day, the dedicated, courageous, professional men and women of ICE work to promote homeland security and public safety by faithfully executing the laws established by Congress to protect the integrity and credibility of our country's borders, as well as our national security and the safety of our communities nationwide. The increase in the flow of illegal migrants and the change in those arriving at our border are putting the migrants, particularly young children, at risk of harm from smugglers, traffickers, criminals, and the dangers of the difficult journey, and are placing unsustainable pressure on our entire immigration system. Ultimately, to solve the border crisis, we must work collectively to ensure the integrity of our immigration system as a whole. Failing to adequately resource interior enforcement efforts, such as fugitive operations, detention beds, and ICE attorneys, creates nothing more than the appearance of border enforcement, creating a pull factor that ultimately drives more people to make the dangerous journey to the United States, incentivizes more illegal activity, and delays justice for those with meritorious claims for asylum. As a nation of laws, we owe it to the citizens of our country to maintain the integrity of our immigration system, especially when faced with a serious and ongoing national crisis. Day in and day out, the women and men of ICE have worked tirelessly with limited resources and an outdated legal framework to ensure the safety and security of our country. They have done this despite villainization, personal attacks, and the toll it takes on their families and personal lives. They pay this price every day for simply doing their jobs under the laws passed by Congress. A crisis is at hand, a change is needed, and it is your responsibility as members of Congress to act. Thank you again for inviting me to testify today. I am honored and humbled to represent the more than 20,000 American patriots with immigration and customs enforcement. I ask that you provide the funding sought in the President's FY 2020 budget, and I look forward to your questions.
Director Albence, as you know, we have serious concerns about ICE's ability to manage its budget within the means provided by Congress. The lack of transparency into how ICE executes its budget also exacerbates our concerns. Under a continuing resolution, operations should continue at the level funded in the prior year appropriation. For the current year, that means ICE should have maintained an average daily population of 40,520 during the CR period. And yet, for the first quarter, ICE use of detention beds surged from 44,000 to over 46,000. And this was before the significant migrant surge at the border. During the period of the CR, did ICE make any attempt to operate within the funding levels identified by Congress for custody operations? And if so, what specific actions did it take?
Thank you, Madam Chairwoman. We continually look to utilize our detention resources in the most efficient manner as possible. Instructions are standing instructions to our field offices, our 24 ERO field offices, to continually look at their populations to ensure that those individuals that are detained are the most appropriate for detention. Again, many of those individuals that are currently detained are individuals that Congress has mandated must be detained by law. 74% of the individuals that are currently in ICE custody are subject to mandatory detention under the Immigration and Nationality Act. The vast majority of those other individuals are individuals who have been public safety threats, who are gang members, or individuals who may not reach the mandatory detention threshold, but we have felt that they're appropriate for detention and not appropriate for any sort of release back to the community. With regard to your question during the CR, the numbers began an uptick the middle part of last summer and continued to rise through the fall, not to the level that we've seen, unfortunately, during the calendar year FY19. However, in order to prevent a wholesale catch and release system, which we knew would create further incentives for individuals to come to the country illegally, we made the conscious decision to try to detain as many people as we possibly could to help prevent a rush on the border. Unfortunately, the numbers continued to come as a result of the fact that many of those people we can't detain because they are UAC or family units.
To better understand how ICE budgets for its operations, the report that accompanied the FY 2019 appropriation directed ICE to brief the committee on a detailed plan for operating within its budget. This was due 60 days after the date of enactment and was to be provided monthly thereafter. The first briefing was due by April 16th. To date, we have not received even one, and by now we should have received 4. Why has ICE failed to comply with this briefing directive?
I will have to look into that specific directive. I do know that we are holding weekly migration calls with the Four Corners staff, during which time both CBP and ICE provide detailed information with regard to their ongoing operations, to include detention and funding execution. We have posted a lot of our material on the website. I do have the list of requirements after our discussion earlier, and we will go through them and certainly have to get back with you with a detailed response on each one of those.
Okay. Just as a follow-up, you know, the department's funding transfer authority exists to address unforeseeable and unavoidable circumstances. But it seems clear to me that ICE routinely operates with full expectation that it will be bailed out by this transfer authority that it has or some other means. As the acting ICE director for the coming fiscal year, I hope that you can commit to operating within the funding level that is appropriated by Congress.
I certainly will do my best to do so. I can tell you that We have numerous budget meetings with very hard decisions made all the time with regard to what operations we're going to have to curtail or what funding we were going to, initiatives we might not have to be able to do as a result of the limited funding. Our detention modeling has been accurate for the past 3 or 4 years, the model that we utilize, and we asked for 52,000 beds in the FY19 budget. Had we received that money as requested, we would not be in any circumstance where we need to do any sort of reprogramming or shortfall.
Just as a reminder as we move forward, appropriation bills are also law, and including continuing resolutions with no less authority than the Immigration and the Nationality Act. In fact, the authority of appropriation bills is derived directly from Article 1, Section 9, Clause 7 of the U.S. Constitution. And I quote, "No money shall be drawn from the Treasury but in consequence of the appropriations made by law." So when Congress enacts appropriation bills, it does so based on informed analysis provided by the Appropriations Committee on how best to target the use of limited resources. So I just want to emphasize that transfer authority is provided by Congress to allow executive branch agencies to respond to unforeseen events and circumstances and not to routinely augment appropriations for a particular activity. And I will pause on my question, and I will now turn to the chair of the full committee, Ms. Lowy.
Passing our final bill of the session, but I am pleased to be here with my colleagues to welcome you. Director Albence, I am very concerned that this administration's policies negatively impact the well-being of our immigrant populations. I'm especially concerned about the effects on vulnerable populations like unaccompanied children. In April 2018, your predecessor, Director Holman, signed an agreement with HHS that provides for information sharing between your agencies regarding the vetting of potential sponsors for unaccompanied children. The mere existence of this agreement has had a chilling effect on the number of potential sponsors who would otherwise have been willing to come forward to take these children out of federal government custody and care for them. Not only does this make the mental and emotional stress these children already face even worse, it has led to significant additional federal costs as children remain in HHS custody for far longer than necessary. It's clear to me that this agreement is misguided at best. So, if I can ask you a few questions. First, how many arrests have been made of sponsors, potential sponsors, or their household members since this agreement was signed?
I don't have the exact number, and we haven't made any arrests since the appropriations bill that was passed prevented us from utilizing that information. So Section 224 of the FY19 appropriations bill prevents us from using that HHS information to make arrests. So prior to that date, I can get to the exact number, but it's going to be around 330.
However, you have the information from the households to which the youngster is going. Isn't that correct? So if the youngster goes to an uncle, and in that household there may be 3 undocumented, 4 undocumented family members, you have that information. Is that correct?
We wouldn't necessarily have the information with regard to individuals that are in the household. HHS has limited some of the sharing of information in various iterations during the course of this MOA. But again, we are prohibited from using that information to take enforcement action against that sponsor.
Given that children may already be present in a sponsor's household, how does ICE ensure the safety and well-being of children excuse me, during enforcement actions, and what arrangements are made for these children?
So certainly, we take the safety of children at utmost importance as we plan any operation. In fact, the entire MOA exists as a result of some tragic circumstances in which UAC were placed with traffickers. This was an attempt to try to prevent traffickers and other individuals who may do harm to these children from being sponsors and getting children into their custody. Our research, as we were going through these cases when we were able to use that information, nearly 40% of the people that were sponsors actually had criminal records. So there are certainly cause for concern with regard to the individuals that were sponsoring the children. With regard to your exact question, we have extensive training that we provide to all of our field offices. We have field office juvenile coordinators. We have a juvenile and family residential management unit up at headquarters and a national headquarters program manager that oversees how our field office juvenile coordinators conduct their operations. We do extensive training with that. Our officers are trained professional law enforcement officers. We're no different than any other law enforcement agency. Once you go into a residence, as much planning as you could do beforehand, you don't quite know what's inside that door. And there are a lot of, every law enforcement agency is faced with challenges when they go into these houses and they find that there are children there that were either unanticipated or that need a caregiver to take care of them. So we work very closely with generally, we're able to find if the parent has another parent in the country that they can have the child stay with, a family member or other relative that the parent consents to letting that child stay with, we will let the child stay with them. And most times that's generally what happens.
Well, as you know, the FY19 DHS bill included a provision that constrained ICE's ability to use information resulting from this agreement with HHS to deport a sponsor, potential sponsor, or a member of their household with some limited exceptions like a felony conviction for child abuse or an aggravated felony. Nevertheless, the agreement still stands, and potential sponsors are still concerned about what would happen to them if they were to offer to become a sponsor. Given that these protections are in place, why has ICE not rescinded the agreement or at least amended it to reflect the protections provided in law? And with these restrictions in place, I'd be interested to know as I conclude, because my time is, well, I'll just ask the first question. Why haven't you rescinded this agreement or at least amended it to reflect the protections provided in law?
There have been some discussions with regard to how we could tailor the MOA in a manner that would be more effective and in compliance with the law. Those have not reached to fruition. But again, I will reiterate, based on the fact that the appropriations language forbids us from utilizing that information, large portions of that MOA have been rendered largely moot.
Well, let me conclude, and I thank you, Madam Chair, for giving me the opportunity as I was on the floor introducing the bill. But I do want to say in my discussions with many people in our community, and we were at Homestead, there's a real concern about providing enough sponsors because they're afraid that they will be picked up or a grandmother will be picked up and someone in the household. So I look forward to continuing this discussion. Thank you, Madam Chair.
Mr. Fleischman.
Thank you, Madam Chair. Director Albence, yesterday we heard from Chief Provost in our Border Patrol Oversight hearing. As you can imagine, we spent a lot of time pursuing questions about the overcrowding and detention facilities at the southwest border. As you would surmise, because HHS received more funds in the supplemental to care for unaccompanied minors, Border Patrol was able to quickly move minors out of CBP sites and into ORR facilities. Conversely, because ICE did not receive funds in the supplemental and didn't receive an increase in the regular fiscal year 2019 bill, CBP is still sitting on a lot of single adults at the border with no relief in sight. Because of this backup, and because the numbers of apprehensions at the border are still astronomically high, CBP facilities, both OFO and Border Patrol, are beyond capacity every single day. The Inspector General has published reports in just the last weeks on the dangers to both the migrants and your colleagues at CBP. What are you doing to ensure that the Southwest border apprehensions are a priority for beds and transport within the ICE system, sir?
Thank you. Excuse me. Let me be first to commend Chief Provost and her CBP team for doing a tremendous job under the most incredibly difficult circumstances that there are out there.
Thank you.
We are in the process of ramping up our detention. Unfortunately, we made a conscious decision during the continuing resolution period to not acquire additional detention space because we didn't know where the appropriations bill would end up, and we did not want to end up further in the hole than we were. So as a result of not getting the appropriations until February, and then starting the process to identify additional beds, and it takes a longer time to turn them on. When HHS gets additional money, they have Homestead, or they have a facility such as that where they can turn on beds quickly. When we want to turn on a facility, we have to generally have to go to a contractor, and they need to recruit, train, hire, vet their personnel, plus get the facility up to speed to meet our standards prior to placing individuals into that. So we've turned on about 6,000 or 7,000 beds during the course of the year thus far. We've got about another 4,000 or 5,000 that will be turned on by the end of August. And that's the culmination of the process that began once we received the budgets and started moving forward. So our modeling indicated to us that we were going to need to have those beds, but we just simply didn't have the funds to turn them on in a timely fashion.
Yes, sir, and I'm clearly empathetic and sympathetic with your plight. In that regard, in moving towards solutions, is money the only challenge, and does this problem extend beyond just dollars, sir?
Well, it certainly does. Again, money helps us better deal with the symptoms of the crisis, and that includes being able to relieve getting additional detention funding to relieve the overcrowding in the Border Patrol stations. They're sitting on, I believe, probably about 8,000 single adult males that are waiting to either be processed or placed in ICE custody. We can't place them into custody unless we have a bed to put them in, and we can't have the bed to put them in unless we have the money to buy those beds. We have done many things internally to improve our efficiency, and in fact, our average length of stay in detention has gone down even while our detention beds have gone up. So we are better utilizing the resources that we have been given. But again, a crisis means a crisis, and there's more bodies that are there than we have the capability to do so. But again, we're just dealing with the symptoms at that point. Unless the law changes that allows us to detain families during the course of a truncated immigration proceeding where they're entitled to due process, but keep them in custody in a safe, secure environment, just like we did in 2015 when we built family detention under the prior administration and we saw the numbers drop precipitously. That will be certainly, and as I mentioned in my opening statement, fixing the Flores settlement agreement will be a huge help to that. The credible fear threshold, again, is part of the problem. A lot of the reason these individuals are holding, these single adults are holding down these beds is because they are getting credible fear because the threshold for that credible fear is so low. But when they actually go through court and get in front of a judge, only less than 10% of the Northern Triangle individuals are actually getting asylum. So there's this different standard which creates a situation where we're holding these individuals in custody for 60, 70 days as they go through that process, and at the end of that process, they're going to be removed anyway. So it certainly makes sense to have the initial screening be more online with what the ultimate decision factors would be from an immigration judge.
Yes, sir. One quick two-part question. How quickly are single adults being repatriated back to their home countries, and do you know the average length of stay in an ICE facility after being turned over from one of the CBP facilities? And I'm beyond my time, so I'll ask for a quick response, sir.
So it depends on the circumstances. A lot of it depends on where the individual is from. Some countries, especially Northern Triangle countries where we have great relations, we have scheduled charters on almost every day if we need them. We can return those individuals if we get the removal order. If they take the expedited removal and don't claim asylum, or once the judge orders them removed, we can turn them quickly. I would say, and I can get you the exact number, I think average length of stay right now for a single adult is going to be in the 40 to 41 day range.
Thank you, sir. Madam Chair, I yield back. Thank you.
Mr. Newhouse?
Thank you, Madam Chair. Thank you, Ranking Member. Acting Director Albence, thank you for being here with us today. And I also want to express my thanks for your service, as well as all the men and women that work with you in helping to keep our nation safe. So thank you very much. I wanted to talk today a little bit about a couple things, but first of all, some thoughts that surrounding a disturbing, violent an attack by an avowed Antifa assailant that was conducted just over 2 weeks ago at one of your facilities in my home state of Washington. In fact, that's a facility that I had the pleasure of visiting a short time ago. And by the way, Madam Chair, with the conditions I observed, I believe that all of the needs of the detainees there were being met very well. And so I just wanted to make sure that you understood that. The things that I observed that were in fact above standards, I would think. But this man, armed with a rifle and an incendiary device, if you recall, attacked the detention center in Tacoma on July 13th. He tried to ignite a propane tank. He tossed lit objects at vehicles as well as buildings. He lit a car on fire. Authorities found, as I had mentioned, a rifle, incendiary devices on him, as well as a knife and also a collapsible baton. I'm very concerned by this. I got to tell you that I think everybody would agree with me that this is pretty frightening to have happen. Certainly thankful that no officers, no detainees were injured or killed in this attack. But what's even just as concerning, but maybe more so, is to hear and read about the things that members of the radical Antifa groups are saying about this man. They're calling him a martyr and calling for more direct action just like this. Unfortunately, this wasn't the first time that this man had attacked one of your facilities. I believe last year, the same individual had wrapped his arms around a police officer's throat during a protest. I've been thinking about this. I think a lot of us have probably been reflecting about what's going on in our country, our national discourse, both here in Washington, D.C. and around the country, and how perhaps this vehemence against our law enforcement and against men and women who are, as you said, doing the jobs we asked you to do to protect our nation and uphold our laws. How is that affecting these people's ability to do their jobs? And I just wondered if you had any thoughts about that, Mr. Director.
Thank you, Congressman. Yeah, I wish that was an isolated incident. As you mentioned, there are significantly increasing numbers of violent protests against our officers who are doing an incredibly professional, difficult job under the most complex and difficult of circumstances incredibly well. Assaults, unfortunately, against our officers are up significantly. They've been on a rise continually over the past couple of years, both on our officers that are out there in the field conducting law enforcement efforts, as well as officers and even our contractors in our detention facilities where they're being attacked and assaulted. And we had a nurse that was punched in the face last year, the trauma that she suffered as a result of that is unmentionable. And I've said it publicly, and I've done some media appearances on it, and I mean no disrespect, but they're picketing the wrong people. Congress is responsible for the laws that we're enforcing. If there is a desire to change the laws, and these people wanted to have the laws changed, they know where Capitol Hill is. They can come over here and picket and do it. But to come after the men and women who are American patriots doing the job, again, they put their life on the line every day when they go out there. And it's not just the law enforcement officers. When we had people trying to storm our office in Portland, right, we had non-law enforcement officers being threatened, having their cars vandalized, didn't think they were going to be out of the parking lot by protesters. That's not right, and it shouldn't be that way. So I would hope that everybody involved in this process and this issue would take a step back and a deep breath and realize that the law enforcement officers are the ones that are comporting themselves in the proper manner in this entire process. And it's those that are wishing that they didn't exist that are the ones that are behaving in an unprofessional and unsafe manner.
I appreciate that, Mr. Albence. And again, thank you for your service and for being here with us today. Thank you, Madam Chair, for calling on me.
Mr. Rupesberger.
Thank you. First thing, I'd like to respond to just what you said. Our country is a democracy. I think we have the best country in the world. Those of us who travel to other parts of the world appreciate it. I think a lot of it is the check and balances. I've worked in law enforcement in the past for over 10 years, and I agree. You have dedicated men and women who work in law enforcement, and they're good people. There are also some bad people in law enforcement, and that few amount of small people give a bad reputation. I think right now this country is split. I think a lot of it has to do with national media on both sides of the aisle where people get their information. I think our president, and I don't want you to respond, he's your boss, has infuriated this issue of immigration, that all people coming in this country are bad and wrong and murderers and rapists and whatever. But your job is to enforce the law, and I agree, and we want to change the law, we need to do that. I think that, but when the average person in this country sees abuses of children and families, that is where a lot of this comes from, and we're concerned about it. We're saying this is not who we are. And then there's certain agencies that are being blamed, and you're probably one of the top. So how do we deal with this? I feel strongly that where you are and ICE is you need to make sure that you focus on the immigration laws, but there are also ways to do this. Now, we just passed a supplemental, and you're going to have money coming to you now to deal with issues. Now, because of the debate back and forth, you're not going to be allowed to use this money for enforcement. You're going to be allowed to use this money for issues such as detention facilities that are better, to be able to put people out that you can't hold, to keep families together in a more humane area. I would personally, and I'm going to get to my question, I would personally like to see ICE focus, and you're known, just like the FBI is known for something, DEA is known for something, you're known for focusing on the felons. That's what you do best. That's what you can do. You need to focus on the felons, and when it looks like you're going after immigrant families with children, and when our president puts out, we're gonna go out there and arrest 25,000 people, or whatever he said that number was. That doesn't help you. It doesn't help our system of justice, and it scares the dickens out of these families who are here because they want a better life. And we know it might be legal, but we're not going to fix this issue until we deal with the issue of volume generally, until we deal with right now, the Honduras and Guatemala and El Salvador country, so that people won't want to come here. And that's out of your mission, really. Your mission is to, when people break the law, you need to enforce it. So first thing, what is your priority as far as the bad guys, so to speak, the felons? And why does it seem, the perception, that you're out there going after people who've been here for years and pick them up and they have families and that type of thing? I think that's where the problem is with ICE and where you have your bad reputation for a lot of people in this country.
Thank you. And unfortunately, I think there's a lot of misinformation out there which doesn't help.
That's why I'm asking the question.
Yeah, sure. So our priorities and our enforcement numbers are largely consistent over the past decade, if maybe 7, 8 years. 90% of the people that we arrest are convicted criminals, which is the largest, and I'm just solely talking about the civil enforcement stuff, not the great stuff that HSI is doing, but 90% of the individuals that we arrest are convicted criminals, charged with a criminal violation, are an immigration fugitive, meaning they've had their day in immigration court.
When they stop right here, felony type or automobile, speeding tickets, whatever?
Well, again, speeding ticket, if it's not, the way we find out most of the individuals that are here in the country illegally is through the criminal justice system. So 3 out of every 4 people that we arrest, in fact, it's higher than that, but 3 out of 4 that we arrest come out of our criminal alien program. Those are individuals that are sitting in the custody of another law enforcement agency after having been arrested by that law enforcement agency for some criminal violation. That's how we are aware of their presence, is once their fingerprints are run through the FBI database, they bounce off ours. So again, 90% criminals, pending criminal charges, immigration fugitives, and individuals that have illegally re-entered the country after being deported, which again, as I mentioned, is a felony. But to your larger point, and with regard to restoring integrity of the immigration system, if we do nothing else besides working the criminal aliens, what we have in effect said that we are no longer going to, there is no longer to be a consequence for anybody coming to this country illegally. Even if you go through the entire immigration court process, which Congress spends hundreds of millions of dollars on every year between ICE and DOJ, that order issued by an immigration judge is not worth the paper it's written on, why do we even have the process? No other law enforcement agency in this country is being asked to ignore a lawfully issued judge's order. And when you say we can only go after felons or only go after criminals, that's what that in effect
But I
means.
say that because that's a priority. There's 11 million people here. You can't go after 11 million people, so you've got to pick your priorities. My time is up. I just want to ask one question. Why do you feel that you are being criticized, that there's so many people in this country that want to ban ICE? What do you, from your perspective, why do you think that's the case, and what do you think needs to be done to change that?
Again, I think it's largely a part of misconception and misunderstanding as to what we do. Look, if you want to talk about abolishing ICE, then that means that
I'm not saying that.
No, but I'm saying, but those that say they want to abolish ICE, what that means is that they don't want 140,000 criminals removed from the country every year. That means they don't want HSI removing 10,000 gang members, arresting 10,000 gang members every year. That means they don't want HSI removing 10,000 pounds of opioids from the street, including 3,000 pounds of fentanyl. That means we don't want the second largest agency on the Joint Terrorism Task Force to exist, for which 54% of the cases are made out of HSI. That means we no longer want to have counterproliferation investigations, and we want sensitive military equipment to go overseas to our enemies. Means
that's a good answer, and that's what you have to get out to the public. My time is up.
Thanks, sir.
I'll get you to the next round. Okay.
Mr. Rutherford.
Thank you, Madam Chair. Director Albence, first I want to say thank you for the job that you and your men and women are doing out there, and really apologize for the Congress and the courts and the position that we have put you in. And I know it's a very, very difficult situation, because not only have we created bad law, but there's also this sentiment in the country that disrespects all authority. The folks that are talking about banning ICE, there was another group that was marching down the streets of New York chanting, what do we want? Dead cops. When do we want it? Now. We just saw on television the other night 2 New York City Police Department officers having water dumped on them. You're absolutely right. People need to take a step back, take a breath, and start respecting law enforcement. I've got some bad news for you. The president asked for $9.3 billion so that you could do your job. We're only going to give you $8 billion, it looks like. So somewhere in there, you're going to have to transfer probably another $1.3 billion around so that you can complete your mission. That's not on you, that's on us. Now, so let me ask you this. When we talk about your budget in ways that you can do your job more efficiently, you mentioned the criminal alien program. When I was a sheriff, I was a lifelong law enforcement officer, 12 years as a sheriff. I ran a 287G program in my jail. I know how efficient and safe that was for your officers, for my officers, and for every citizen in my city. And I have to tell you, my blood boils when I see these cities say that they're not going to work and coordinate with ICE, because let me ask, do you think it is safer for you to go into a jail and arrest these criminal aliens? And these are the criminals that my good friend is talking about down there. These are the ones that 90% of your arrests are out of these jails. So is that safer?
It's absolutely safer. It's safer for our officers, it's safer for the individual we're trying to arrest, and it's safer for the general public at large.
And can you comment, is it cheaper?
It's certainly cheaper. And to give you perspective, we used to get, before this issue came up with sanctuary cities and people not wanting to honor detainers, I'm talking to the field office director from Los Angeles at the time, he said they used to get 200 criminals a day out of LA County. That's dwindled down to a handful now, based on state laws that are there. I mean, that is something that we have asked Congress for, and look, everybody is safer. Every community is safer when law enforcement works together.
Absolutely.
We all take the same oath to uphold the Constitution and to keep our communities safe. So we're all better when we work together. That said, there are many law enforcement agencies that would like to work with us, but due to some court decisions or due to some executive orders or state laws, or just the fear of litigation and liability, they're reticent to do so, or their county board of supervisors or legal department won't let them. We've been asking Congress for years to codify the detainer and indemnify sheriffs or local law enforcement agencies that honor those detainers.
Right.
Most sheriffs, if they know that they are indemnified from tort actions or that a habeas claim that is made from an individual being held on a detainer, they will gladly take them up.
Right. And look, the detainer issue, I understand some people throw that up as a red herring argument, but look, I'm going to tell you, all I have to do is call ICE, and before that individual is changed into their street clothes, ICE can be there to pick them up. It's just a coordination effort. So I think that's a red herring that folks throw out there that just don't want to help ICE get these people out of our country. Now, I saw a CBS report in Miami saying that 37 Florida agencies have agreed or show an interest in being part of the 287G program, but that there were delays in getting these agencies into the program. Now, I think you touched on a little bit of it. Can you talk about what some of the other delays might be getting into that? Is it budgetary for them or for you?
No, part of it is budgetary for us. The 287G budget has remained static for the past 4 or 5 years since I directly oversaw it. That has part to do with it. Part of it has to do, look, if we're going to give somebody delegated immigration authority, and as a 287G partner, we don't take that lightly. We vet all those individuals that are, even though they've been vetted and have a background check by the local agency they work for, we vet them ourselves to make sure that we are comfortable with who we're delegating that authority to. Sometimes there's facility infrastructure with regard to T1 lines so that we can install our computers and the like. So there are some logistics. We're trying to move as quickly as possible. We do have a new program called the Warrant Service Officer Program, which is a subset, a very limited delegated authority to just execute warrants on our behalf. At the direction of an ICE supervisor or officer. And Florida actually was the first place we rolled that out. We rolled out in 9 counties, and we're continuing to expand.
Yep. And we appreciate the partnership that we've had with ICE for a long time. And Madam Chair, I see my time's run out, but thank you for your service.
Ms. Wasserman Schultz.
Thank you, Madam Chair. Director Albence, I don't want to pursue this line of questioning if you're not specifically familiar with the ongoing issues at ERO Miami in Miramar. Are you familiar?
I'm fairly familiar. I've been there, and I know that my staff back briefed me after they briefed you a couple months ago. So
okay. So after that meeting with them, and we got the detailed answers to questions, there were a number of questions that they really didn't give us an answer for. And these issues of poor infrastructure, people standing out in the blazing sun, security that is working with ERO Miami, treating undocumented immigrants rudely, still prohibiting them from being able to have volunteers distribute food and water. Those issues are all continuing, and we've gotten insufficient answers related to canopies, bathroom expansion, and other issues. I would like you to take this document that I can get you a copy of. I want to share with you the concerns that I have on the answers not being adequate. I still need an answer about what is being done to follow up to make sure that security officers at the facility are not treating the people who are presenting at the office with an appointment rudely, speaking rudely to them, refusing to speak to them in Spanish, and really giving them a general hard time. It's a very small parking lot. There is no coverage whatsoever, and I realize this parking is going to be expanded, but that won't happen until next year. Additionally,
Ma'am, can I answer, because I do have some updated information if you'd like.
Yeah, just let me get this all out so because I have another question I want to ask you. The other issue that was not answered adequately was a letter is sent to an immigrant who is told to come for a specific appointment. When they get there, they are told that they have to call the phone line, and not only that the letter is insufficient. When they call the phone line, they are not connected with a person who speaks their language. The only option is in English. The answer that I got in writing was insufficient and didn't provide me with an answer other than the policy about what's supposed to happen, rather than trying to get to the bottom of what's actually happening. And then the other insufficient answer related to the distribution of food and water by volunteers. I understand that in the letter that you sent to me, in the memo you sent to me, you detail that they're instructed in their letter to bring adequate food and water while they wait, and that it's your liability that is an issue with allowing volunteers to distribute food and water. That makes no sense to me. If you look at the configuration of that parking lot, there's no obstacle or damage or harm that could come if people are simply allowed to bring food and water to help make sure we can relieve the difficulty of the people there. So if you could answer those questions and give me more substantive, specific answers to those concerns, I'd appreciate it.
Sure. So I did ask for an update before him. So I know the outdoor water fountains will be ready for public use on August 9th this year, and the new parking lot will be open to visitors on August 22nd.
The new parking lot in August, not next January?
August 22nd, right here. So
okay.
I know that there's a permanent canopy project being looked at. Again, it's a GSA obviously is involved. I know they were in the briefing with you.
Yep.
And I've been to that facility about a year and a half ago, and I expressed concerns with regard to the conditions in which the employees were working in too, because they're very cramped in there.
It's really cramped.
It is. So, I mean, across the board. So I know it's being reviewed by GSA and our Office of Facilities and Management within ICE to try to, for pricing and getting a contract vehicle to put that in. So we are moving forward on that.
I appreciate it, and I just, there's another.
We can give you just.
Yeah, I just need to talk to you more in detail about the concerns.
Happy to come talk to you anytime.
Thank you. The other question I want to ask you real quick. I chair the Military Construction Veterans Affairs Subcommittee, and what we're concerned about is that there are conclusions in a report written by GAO that looked into ICE's failures to consistently follow your own policies when moving forward with removal proceedings for non-citizen veterans. According to GAO, some veterans who were removed may not have received the level of review and approval that ICE has determined is appropriate for cases involving veterans. The report also concluded ICE does not know exactly how many veterans have been placed in removal proceedings or removed, or if their cases have been handled according to ICE's policies due to a lack of consistent record keeping. So these are really disturbing deficiencies. Are you and your agency currently working to ensure consistent implementation of ICE policy for handling non-citizen veterans? Are you working to develop a policy that makes sure you know how many veterans are in your system and that they are being interviewed properly? And finally, the report recommends that ICE maintain complete electronic records on veterans in removal proceedings or who have been deported. You don't have a system like that. Have you established one yet?
The military veterans is something obviously that we're very sensitive to. They do require and do get a much higher level of scrutiny than an ordinary removal case. Oftentimes are kicked up to headquarters.
The GAO report says that they're not getting
Again, oftentimes are kicked up to headquarters. We don't have, and I know it's been discussed, I don't know where we stand, but I'm certainly happy to get back with you about trying to find a code in our system that we can put in there so that we can readily identify which cases are military, so then when we're asked questions about them or need to produce reports, it would be easily done. But with regard to having a complete electronic record, we simply don't have the system to allow that. We've made requests in the budget for many years to have upgrades to our systems that haven't been funded. So absent significant amount of funding that would allow us to have an electronic system of record that would have a whole A file. I know CIS is working on something to that effect, but we don't have anything like that.
Madam Chair, I know my time's expired, but these are people who have served our country, and they are supposed to be given a heightened level of review as a result of serving our country, even though they are undocumented immigrants. If you don't know how many of them are in your system, then it is nearly impossible for you to be able to treat them with the dignity and respect that they deserve and thank them for their service. So just, I mean, you can't just say we don't have enough money or the capacity to do that. You have to be able to keep track of those.
I was speaking to your last question with regard to an electronic A-file system, basically is what you sounded like you were looking for.
Right, it is. So you know how many are in your system.
Again, the funding for that is not available. We have ways within our existing system that I think can be tweaked that would allow us to do that. But again, most of these individuals are a lot of them actually aren't undocumented. They were lawful permanent residents that actually were convicted of aggravated felonies, which is how they ended up being removed.
That's a different situation. I'm talking about the people who aren't. Thank you, Madam Chair. I appreciate your indulgence.
Ms.
Yield
Bing.
back.
Thank you, Madam Chair. Thank you, Mr. Director, for being here. Wanted to ask about the Family Case Management Program, ATDs, Alternative to Detention. In June 2017, ICE terminated the Family Case Management Program. The daily cost of family detention per individual is approximately $300. However, case management programs cost around $36 a day for one family. Just wanted to ask why ICE decided to terminate the Family Case Management Program.
Thank you. The Family Case Management Program was a program that was incredibly expensive for what the ultimate result was. So, for example, in the 18 or so months that the program existed, there were only 65 cases that were concluded. 41 were actually terminated for noncompliance, meaning the individuals didn't show up to their hearings. 8 individuals self-removed, 7 were issued a removal order or voluntary departure from an immigration judge, and 9 received relief. So for the $17 billion or so that was invested in that program at the time, we received 15 removals, which was about $1.16 million per removal, as opposed to, and with regard to compliance, the rates under FCMP were actually a little bit lower than under our standard ATD program, or ISAP, intensive supervision program, excuse me. So, in fact, this shows some of the challenges with dealing with cases in a non-detained environment. 3/4 of those cases, more than 3.5 years later, still haven't been decided by the immigration courts. So that shows some of the backlog. So if we had kept this program at the cost that we were doing, we'd probably be up to $26, $30 million right now, with maybe another $20 or $30 million more to go for less than 1,000 cases. It's just not good fiscal sense to try to keep that. Now, there were some things in this program that we found useful, that we've incorporated to our current ECMS, our existing case management system that's outside of FCMP, and those that we've implemented in there where we found that might have some use, we've implemented that and put that in there.
So, I mean, the OIG reports that the Alternative to Detention Program had compliance rates of 99% for ICE check-ins and appointments and 100% attendance at immigration court hearings. When you're measuring success of the program, does ICE include immigrants that it removed from the program who then later failed to comply with the requirement? And shouldn't the program only measure compliance of those who are consistently and actively within the program?
Well, the ultimate purpose of the immigration court system is for an individual to be availed all due process and make their case in front of an immigration judge as to whether or not they have the lawful right to remain in the United States. So the ultimate measure should be whether or not the order issued by the judge is actually adhered to. What we have seen is that the number of individuals that are actually removed, which most of the individuals at the end of this process receive a removal order. It's just the way it is. Most of the individuals that make an asylum claim or apply for some sort of withholding or other form of relief generally don't get that. So most of the cases that go through the immigration court end up with a removal order. ATD, over the past several years, has been fairly level at removing about 2,700 people that are on ATD. In fact, between 2014 and 2017, the ATD budget more than doubled. It went from $91 million to $183 million. And as a result of that $92 million investment, we removed 273 more people. That's it. If that same dollars had been put into detention, we could have removed 10 times the number of people as we did that were on ATD.
I do want to, you mentioned that there are parts of the program that have been useful. These programs, as you know, are more humane, helping vulnerable families with young kids, pregnant women, people with health concerns, victims of domestic violence. And would there ever be potential to improve programs like this, such as working with nonprofit organizations? A lot of them are more equipped to provide case management assistance to immigrants within the communities that they serve. And I just wanted to know what the status of incorporating nonprofit organizations into these sorts of programs to provide gap services that GEO Care might not be providing.
Right, so we work very closely with nonprofits. We were given some additional funds in 19, as well as in the supplemental for the ATD program, which we're utilizing to help try to make that program more effective. But one thing, you know, and it was asked previously, and it's asked frequently, both here and in the media, is you hear these cases of individuals that have been here 6, 7, 8 years, have been complying with all their check-ins, and then why does ICE arrest them? Well, that's what the back end of ATD enforcement looks like. Those individuals that have been here for 6 or 7 or 8 years have most times been appealing their case to the Board of Immigration Appeals, to the Circuit Court. They may have filed a petition for review, a motion to reopen. Those cases drag out. When we talk about a crisis, having 3 million cases that are unadjudicated in the immigration court system is a crisis as well. So it takes these cases so long to get through the process that these individuals are here for 6 or 7 years. But ultimately, the judge orders that individual removed, and we're sworn to execute that removal order. The Immigration Nationality says, you shall take into custody. To me, I think if you're looking at the entire enforcement continuum, and obviously, you know, if we have a system whereby we can detain individuals for a short period of time and they can avail themselves of all due process, make whatever claims they want in front of an immigration judge and have them adjudicated in a short time frame while they're in custody in a safe and secure environment that is sanitary and well run and meets all of our standards, and can have a decision on that case in 40, 50, 60 days, to me, that's a lot more humane than having some individual out on the street for 5 or 6 or 7 years where they get a family, have children, develop roots, all the while knowing that they have no lawful right to be in the country. And then when we go to effectuate that removal order, we're tearing families apart, or it's just the poor non-criminal non-immigrant. I think it's more humane to do it on the front end and let them have their day in court. If they're entitled to stay, the judge will let them stay. If they're not, then we execute the removal order. And I think, frankly, that will reduce the pressure you're seeing on the border. The reason you're seeing all these people coming to the border is because they know we can't hold them.
Well, I just want to end by thanking you for acknowledging the importance of humane and swift treatment for these families, keeping them together. And you talked about all the legal options that they pursue. That is their legal right to do so. So thank you. I yield back.
Mr. Aguilar.
One item that concerns me, you've talked about U.S. citizens in response to a question, U.S. citizens that have been detained. ICE has a history of incorrectly detaining U.S. citizens. 2 citizens in my district were detained by ICE and were later awarded settlements to compensate them for the arrest. In the FY 2019 DHS bill, we required ICE to issue statistics on the detention of U.S. citizens. The bill gave ICE 6 months to complete the report, which was due in May. We haven't received any of that available information. If a person can prove their citizenship with a passport or birth certificate, why are they being held further by ICE? In what circumstances would that happen?
So I will check on the report just first off, so I apologize, and I'll look into that to see where we stand on that. We have a specific policy with regard to how we handle individuals who are making claims to United States citizenship that are in our custody. ICE does not have the lawful authority to say anybody is or is not a citizen. What we do is when we are provided with probative evidence that an individual in our custody looks to be a citizen, we will release that individual from custody and then instruct the individual how to go to CIS and do whatever paperwork they may need to do to actually get a naturalization certificate or a documentation of citizenship, whatever the case may be. So that's the process we utilize. A lot of the people that end up being citizens in our custody didn't even know they were citizens. They actually don't find out. The immigration nationality is very complex. The naturalization charts, we used to have to memorize them in the academy, and that was a long time ago, and I can't tell you I memorize them anymore, but it's very complex, and some of the individuals don't even know that they're citizens until we actually start to investigate their background, and we realize that, oh, they are in fact a citizen, at which point we obviously,
Director, I'm not talking about cases where an individual finds out that they're a U.S. citizen. I'm talking about cases where individuals have clearly said that they're citizens. What troubled me with your answer is that when someone looks to be a citizen, I've got a list here of 9, Guadalupe Plasencia from San Bernardino, from my community, Sergio Carrillo from Rialto, but from Austin, Texas, 5 days detained, 2 days detained. These are U.S. citizens or individuals who were born in the United States and U.S. citizens or have been naturalized. These aren't individuals who found out that they were U.S. citizens, Director. These are individuals who told your officers that they were U.S. citizens. and you're talking within the process of this that you advance it when they look to be a citizen. It just strikes me that all of these individuals are Latinos, and that you're talking about how someone looks. So can you talk to me a little bit about this?
I was not referring to anybody's appearance, and that was clear if anybody listened to the context of what I was saying. I'm saying when we review the individual, make an interview, look at their documentation. If the documentation shows, I'll use the term shows that they have evidence, probative evidence of being a citizen, then that's when we release them from custody. I can tell you from my experience, and it had happened to me personally, many individuals who are citizens in a border environment, especially if they're involved in, primarily when they're involved in criminal activity, will claim to be a non-citizen because, especially when they were Mexicans, and I was working smuggling cases as an agent in San Antonio, they would claim to be a Mexican national because they knew that they would get turned around 5 hours later, they weren't going to get prosecuted, and they could come back in at will. So again, we look at all the information that is in front of us to make that determination. Look, we have no lawful authority to hold U.S. citizens. We don't want to hold U.S. citizens. That is not our business or our job. But we have to look at the evidence that's available.
But it's also
to us.
difficult. In prior discussions we've had in this committee, we also found out that within the drop-down box that you had for where an individual's from, United States isn't in that drop-down box. So it's even difficult for you to track how many U.S. citizens you detain, even for a small portion of time. What type of racial profiling education, what type of training do your officers receive? So with specifically applying to U.S. citizens, so we can be certain that this doesn't happen as much. 3 days, 2 days, 5 days, 3 weeks. There's been cases recently in the press, U.S. citizens, members of Congress, finding U.S. citizens who were detained not in ICE custody. I just want to make sure that we're learning through this. So can you talk a little bit about the training that you receive specific to racial profiling?
Sure, and there's no tolerance for racial profiling in ICE. It starts at the basic training level, where our officers and agents receive training on racial profiling at the very beginning of their law enforcement career. We abide by DHS policy, we abide by DOJ policy with regard to racial profiling or cases that are being prosecuted. It is continually something that is stressed in our in-service trainings. We have supervisory schools, we have advanced law enforcement training. There is no tolerance for racial profiling.
Yeah, I guess I'd still like to follow up a little bit more on the documentation piece. If someone presenting, I don't carry my birth certificate, but if someone has these documents and is claiming to be a U.S. citizen, what's the disconnect? Why are they continue to be detained? I appreciate it. Thank you, Madam Chair.
Mr. Cuellar.
Thank you, Madam Chair. I represent a lot of Border Patrol agents, a lot of CBP officers, men, women in blue, field operations, a lot of ICE officers also, from San Antonio down to Laredo and down to the McAllen area. And I have to say, I do appreciate the work that the men and women do. I don't think you all should be demonized. If there is an issue with the policy, we go after the policy. We don't go after the men and women. If the current law and some of the immigration laws that we have been around for years, and it usually says laws passed by Congress, you shall do certain things. So I just want to make sure that if there's a bad apple, we go after that bad apple. And I think you agree with me, but I just want to say that your men and women are probably the same people that were working under the Obama administration, now under the Trump administration. Again, not the men and women, but the policies. Or if somebody wants to change the shall do certain things to the law, then Congress should go ahead and do that. You also have certain protocols that you follow, and because there are folks that say that there are no protocols. I mean, for example, you have the Performance-Based National Detention Standards of 2011, which I think was revised in December 2016. And that one, again, took the input from non-governmental organizations and other groups to make sure that we improve medical, mental health services, access to legal services, religious opportunities, improve communication with detainees that have limited proficiencies, et cetera, et cetera, et cetera. On top of that, we also have in the appropriations, and I started, I guess, in 2014, so I'm looking at from 2014 on, there are riders that we've added, both myself and other members, that talk about
detention standards that talk about transparency in ICE detention centers, that talk about ICE detention facility contracts, for example. One of the sections that prohibits ICE operation and support funds for being used to continue any contract for the provision of detention services if two of the most recent overall performance evaluations received by the facility are less than adequate or something equivalent to that. So there are, there's other provisions dealing with ICE on this. So one is to make sure that we understand there's a particular protocol and language that we have there. Also, on top of that, I think the ICE non-detained docket is 2.4 million individuals, roughly. We're adding about 10,000 cases to the immigration courts every week. There's over 1 million subject to final orders of removal that we have. And then out of the detained docket, I think it's less than 2% of the undocumented individuals are actually in ICE custody across the 200-plus facilities that you have. So now that I've laid that out, tell me your response on the protocols, the laws, the workload that you have, and the environment. And again, I want to make sure that we treat people with respect and dignity. I'm talking about the folks that are under your facilities on that. So give me your quick perspective on what I just laid out on the structure that we have there.
Thank you, Congressman. I wholeheartedly agree that it is imperative that those individuals that are within our custody are kept in a safe and secure environment and are treated humanely and professionally and with dignity the entire time they're in our custody. And that is what we endeavor to do, and that is what our standards do. Our PBNDS 2011, I think, is probably thicker than this. And we're actually in the process of revising some of our detention standards, and we've actually worked closely, and I know the staff here has worked very closely with our custody management division with regard to updating some of those standards. So,
I'm sorry to interrupt. So you're working with the Appropriation Committee, and are you working with
NGOs? We have NGOs. We have a lot of NGOs that work in the immigration space. We actually invited law enforcement in as well because they're the ones ultimately when we contract with these county facilities that have to implement and use some of these standards. So we want to make sure that what we do is meaningful. And some of the standards that we have are 20 years old that aren't relevant anymore. For example, when you talk about they need to have a locksmith on their staff that's a certified locksmith, some of these jails don't have key locks anymore. So we would have to ding them or give them a waiver when we do those inspections. So we're trying to make them more relevant to today's technology.
Thank you.
Mr. Price.
Thank you, Madam Chairman. Mr. Director, let me return to I think it was Mr. Ruppersberger's line of questioning about the targeting of detention and deportation. I would say very baffling claims and counterclaims that have often been made in this area. You gave us that breakdown. That you didn't give us a breakdown, and I want to ask you to do that. It was the ERO arrests was the category, and you said 90% of those arrests either have prior criminal convictions or pending criminal charges, or they're immigration fugitives, or they were previously removed from the country and have illegally re-entered. What's the breakdown of that 90% in terms of those four categories?
About 66% are convicted criminals, about 21% are pending criminal charges, about 2% are the fugitives, and 1% would be the illegal reentrants.
When you say prior criminal convictions, what's the range of criminal?
The range of criminal convictions and the vernacular we utilize is the same as utilized throughout the law enforcement community. Anybody who has been convicted of a criminal violation. And in fact, we only get fingerprints from local law enforcement agencies when they submit them for a criminal violation. So
is entering the country illegally, being apprehended, coming back in, is that a criminal? I don't know. I just want to get clear. How many of these people are violent criminals? As we often say, a threat to the community.
So Our 2018 report is online. Off the top of my head, 2 of the top 5 I think the top charge is DUI. Then I know within that top 5 is drugs and assaults. And I don't have those numbers directly in front of me, but they are on the website. We could certainly get them to your office this afternoon easily enough.
Well, it would help to, I would say, break down these categories a little more straightforwardly, knowing that as we discuss the prioritization, the exercise of prosecutorial discretion, you know, the point of that discussion is to prioritize dangerous people in terms of whatever else we do in the area of detention and deportation, to prioritize people who are a threat to the community. Knowing that that's the purpose of the discussion, it strikes me that there'd be a much more helpful way to present these statistics than, 90% sounds great, of course. I mean, I know why you would frame it this way, but even 66% prior criminal convictions, I mean, that begs for a further breakdown. Knowing, just being very straightforward here about the purpose of the policy, the purpose of the discussion, the purpose of the targeting, which on this subcommittee we have worked on for many, many years. And by the way, nobody's saying everybody else gets a free ride. But we have said for years that given limited resources, given the fact that we are going to deport maybe 400,000 people a year out of 11 million people who are here, that there is going to be discretion exercised. And that discretion needs to be intelligently and appropriately exercised to remove dangerous people. So it would help at least to have statistics that are responsive to that concern.
I fully agree, and I wholeheartedly support being transparent. We have quarterly calls with the media with regard to all of our statistics when it comes to immigration enforcement. Our end-of-year report is about 20 pages long. It breaks down by nationality, by country, by crime, all sorts of things. I mean, thankfully, there are not 40,000, 50,000 murderers that we need to arrest every year.
Thankfully, they're not, but it'd be helpful to know how many actually there are.
About 800 last year.
And whether we're prioritizing those people. Anyway, I'm going to ask you to break down that prior criminal convictions category more precisely.
Happy to do so, sir. Thanks for the time yesterday. I appreciate it.
We know to what extent we're dealing with violent criminals. My time's fast running out, but let me just quickly give you an example of another way to frame this. This has to do with the daily count of detainees, a slightly different universe. But from September 16 to December 18, there's a 22% increase in the daily count of detainees. That's from 39,000 to 47,000. But the number of individuals who had committed serious crimes dropped by over 1,200, despite that overall increase. And the number of immigrant detainees who'd never been convicted of even a minor violation grew by 8,300 people. Now that's a different framing of statistics that puts a very different light on the situation. I just think in a way, the beginning of an intelligent discussion here, especially a discussion of appropriate targeting and prioritization and the exercise of discretion, needs to be a more straightforward presentation of the facts. And I think what I just gave does indicate that we've had some slippage, considerable slippage, in the degree to which we're targeting dangerous people.
So exactly what happened there is exactly what's going on at the border now. Though that is a result of all border cases. That is when the border surge began. So all those non-criminals border cases that are in our custody are mandatory detention cases because they're under the expedited removal process as dictated by Congress under Section 241 of the INA. And the reason that the criminals dropped is because I had to redeploy officers from working the criminals to deal with the border surge cases. That is a direct result. And when we say it's a crisis, it affects the entire immigration enforcement continuum. And it does make everybody less safe because we are able to arrest fewer criminals. I mentioned in my opening statement, we're down 14%. We're going to arrest 18,000 less criminals this year directly because of what's going on at the border. This crisis is not limited to the border. These individuals are not staying in the border communities they're dispersing into the country. And we have to manage those cases. Some of those individuals are getting involved in criminal activity, and we have fewer and fewer resources to actually deal with that, unfortunately.
We'll return to this. Thank you, Madam Chairman.
Director, before I ask my question, I just want to respond to something that you mentioned in your response to Ms. Wasserman-Schultz, a question about the ability to provide reporting about ICE's detention and removal of military veterans. You mentioned that part of the problem is due to a lack of funding to modernize your systems. In the 2018, Congress provided an additional $6 million for this purpose, and in 2020, I recommended an additional $2.5 million. Both additions are above the administration's budget request. I'm also recommending an additional $2 million for your Law Enforcement Systems and Analysis Division, who do the analysis and the reporting. And I'm trying to help by adding funding above what you're asking for. And if this isn't enough, I think it's important that you tell us exactly what it is you need so that you can be more transparent about your operations. I'd like to just follow up a little bit more on some of what Mr. Cuellar was talking about with regards to detention facilities and the conditions that are there. And I have several questions, so I'm going to try and ask as many as I can in the time that I have. First of all, it's really unacceptable, the substandard conditions at ICE facilities that have been reported, and also that which I have myself seen in my visits. And I'm hoping that we'll be able to make some progress on that together. So one of my questions is, have you carried out a full review and taken the necessary corrective actions to ensure that the recommendations from the OIG and the GAO and ICE's own standards and oversight recommendations are being implemented at every detention facility that ICE operates?
Thank you. Yes, we have a comprehensive oversight framework that we utilize. I would say that our detention facilities receive more scrutiny, and appropriately so, and we have no reason to have any reason not to have that scrutiny, and we welcome transparency. I mean, we have detention service monitors that work for headquarters that oversee facilities out there in the field. We have, in many of these larger facilities, we have assistant field office directors that are on the ground to deal with issues on a day-to-day basis. Some of these detention service monitors are on site. We have, and thanks to you and the committee for the additional funding in 19 for OPR, Office of Personal Responsibility, the Office of Detention Oversight. We received able to fund 14 more positions. And
what is the status of that hire?
So the 14 positions will be on board by the end of this FY, and we expect to be able to do, I believe, and I can get you the exact number. I thought we were about 15. We plan to do about 15 more inspections this year than we were able to do last year based on the additional funding. And obviously, once we get those new inspectors on, that will only increase going forward.
Okay.
I'm sorry.
No. I'm just trying to get all my questions.
Oh, go ahead. Go ahead.
But, you know, we continue to hear disturbing reports that ICE is contracting for additional detention capacity where basic standards are not being met. One example is a relatively new facility in Texas that does not allow contact visitation unless there is a significant advanced planning. ICE standards state that contact visitation should be provided, especially when minor children are involved. And remember, we are talking about civil detention, not criminal detention. And my question is, do you believe it's acceptable for ICE to enter into these agreements to provide detention, civil detention services where reasonable opportunities for contact visitation with families and attorneys can't or won't be required, which is contrary to your agency's own standards?
I'm not familiar with that facility, but I'll certainly look into it. On the larger question, as you well know, all of our contracts that we're required to enter into without any contract that we enter into is supposed to be at the PBNDS 2011 standards. And then if we don't meet those standards, then we are supposed to notify Congress 30 days prior to actually entering into that contract, which we have done. And those notifications have actually probably been fairly few. Since I'm not in ERO day-to-day anymore, I can't tell you how many there are, but I only remember 1 or 2 that we sent when I was the EAD. But I know all the new contracts that we're doing in order to get these additional capacity to deal with the border cases, we're contracting at the PBNDS 2011 level.
Okay. The note that I have here that this is in Montgomery County and that it was started using it October of 2018. Okay. So if I could get some additional information.
Happy to look into it. Thank you.
Okay, thank you. Mr. Fleischman.
Thank you again, Madam Chair. And thank you, Director Albence. This testimony is very informational and helps us all do our job. Mr. Director, the DHS Secretary sent a letter dated March the 28th that states, and I quote, "Without additional assistance, we will be forced to increase the releases of the single adult population from ICE, the only population for which we can currently effectively enforce U.S. immigration laws. When meeting with Border Patrol agents, the point is made time after time that if we can't keep up with detaining and returning single adults, we've lost the border." Question, do you agree? Does the sentiment of the March 28th letter still hold?
Without a doubt.
How can we make sure that we don't lose ground on this population, sir?
Again, just dealing with the symptoms now, absent additional capacity, I don't know how you would do it. There is not a way to move these cases through the system really much quicker than they currently do, and we certainly need to make sure that the individuals have all ability to access their due process rights, and so if they want to have appeals of their cases and the like, they certainly are free to do so, and we want them to have all due process. So absent additional capacity, there's only so many beds that we have and only so quickly we can turn them around.
Yes, sir. From your testimony earlier and from what I've seen, it's evident that resources alone won't fix this crisis. This is a very complicated set of issues, or would have been solved by now. Again, going back to the March 28th letter, the Secretary referenced a legislative proposal to Congress in the coming days to address the immigration and asylum policies. My question, sir, do you know the status of an immigration proposal from the Department or the administration, and will we see an official proposal, sir?
Congressman, I don't know the exact status. I can tell you that I know what the proposal contained, and it would have contained the items that, among others, but the three main items that I mentioned in my testimony with regard to Flores, the TVPRA, and the credible fear threshold. But we can certainly check on and get back with you.
Yes, sir. Mr. Director, recent outbreaks of measles, mumps, and chickenpox have closed thousands of beds as you try to limit the exposure to just the affected cohort. How are you managing to contain the outbreak, and how many detainees are ill, and how many beds are affected?
So it changes. I'm not sure how many we have. For the past 6 to 8 months, it's generally been around 4,000 to 5,000 beds that are cohorted as a result of diseases. And frankly, that makes a point which I should have made, so I appreciate you for bringing it up. Even with the expanded capacity, when we have to quarantine a whole wing, we can lose. So there's, at any one time, we may have 1,500, 2,000 beds that are actually vacant, but those beds are within the quarantine pod such that we can't utilize them.
Yes, sir. What efforts are you making to ensure detainees at the affected sites, specifically and across ICE facilities, have unfettered access to medical care, and what efforts are underway to make sure the population isn't introduced to new outbreaks, sir?
Again, we would, with regard to not introducing the population, we utilize all standard practices within the detention environment, to ensure that those individuals are quarantined and kept separate from the general population and are not released from custody until we're certain that they're past the incubation period and are clear. With regard to medical, and again, thank you to the committee for the additional medical funding that was in the supplemental that we put directly to use. We've been leveraging some additional resources from public health. As I'm sure you're aware, we have sworn commissioned public health officers that do a lot of our medical and oversee our medical program. And that includes doctors, nurse practitioners, social workers, the whole plethora of medical services that are provided. And they do a tremendous job. And their sole existence, and they take it to heart, is to ensure the safety and care and health of the individuals in our detention.
Yes, sir. One final question. When do you anticipate the outbreak will pass, and what actions will you need to make the facilities safe to use again?
If I knew that one, I'd be in Vegas. I mean, the new people come in every day, right? The Border Patrol has no idea what they're going to catch, and we have no idea what diseases individuals they're catching may have. So my guess is it's not a new phenomenon. It's just expanded because the numbers have expanded so greatly. But we've had to do this in the detention realm for as long as we've held aliens.
Very well. Madam Chair, I yield back.
Mr. Rupesberger.
Yeah, I want to talk a little bit about alternatives to detention. About maybe a month and a half ago when I visited the border, witnessed significant overcrowding. We know, again, I think the biggest issue we have now is volume. And whether it's judges, whether it's dealing with this problem, and we're having a serious problem. I said yesterday in the hearing that the Border Patrol agent said, you know, when we make arrests, it used to be we'd see them in court or whatever, and that's what we do here. Well, now you have a whole nother dynamic to your mission, and that's holding these individuals. I want to talk about discretion with respect to your agency. You have the discretion to release many of the nonviolent, non-flight risk detainees on parole or bond. Now, home visits, check-ins, telephone monitoring, GPS monitoring, ankle bracelets are options at your disposal. Again, looking to what your mission is and what I think, and Congressman Price and I both have tried to focus on the bad people, the individuals that are really, that we need the expertise of ICE officers to go after. That's where I would like to see your mission, and I would like this country to understand that. And what a lot of people are seeing is that we're going to come out and get you, and families that have been here and they're afraid, and local governments aren't working with you. I mean, it's not where it needs to be. Now, my question is that I think we provided $20 million for alternatives to detention, and these programs are less costly to American taxpayers, more humane in standard detention, and they come with court compliance rates, up to about 90% when you do put people in these type of situations. How fast can you expand alternative to detention programs to reduce this overcrowding? Which I believe helps you, it helps our country, it helps the image of what a lot of people are seeing is abuse of people and families and children.
So most of in fact, unless a small percentage that claim negative credible fear within the family residential center environment and are found not to have it, are released into the community. We have, at this point, based on funding, we have about 101,000 individuals on ATD. We could put, based on existing funding, about 64,000 people on the GPS bracelet annually and keep them on there. At our current volume, that's about half of the number of people that came in the month of May, at which point we would not be able to put anybody else on a bracelet until those individuals came off. And as you well know, on the non-detained docket, those cases may go 3, 5, 7 years, such that we would be able to put very few individuals on a bracelet from that point forward, meaning everybody else would just be released. And frankly, what we've seen, and which goes to why we've surged so many resources from HSI to the border to deal with these fraudulent family units, is that the absconder rate for these family units is far higher than it ever was for the single adults that we used to use it on. So it's about 26% right now of the absconder rate for family units on these GPS. And I mean, we've got criminal investigations that HSI has ongoing in which we have surveillance, or individuals under surveillance and watching them cut off the bracelets. And again, I think a lot of it comes to the fact that these aren't real families. It's individuals that are single adult males that are renting a child in Mexico, paying a smuggler or a cartel, or the cartel for that child, bringing them into the country, and as soon as they're processed and released, they can care less what happens to the child, and they go on about their way and cut their bracelet off. So again, there's some success with regard to showing up at hearings and meetings. That success drops precipitously once the individual nears the end of their process, because the chances of them getting a removal order are going to be higher. If they're going for a status hearing or a merits hearing, they may not get an order. So
let me stop you there because I've only got a minute. In policing, you have your job is to protect our society and arrest when people break the law. So in some area where you have, and I'm from the Baltimore region, I represent Baltimore City, and they've got a bad rep right now. We have to work on trying to turn that around. Part of that is, do you have a system or somebody focusing on community-type policing? So instead of everyone who is here waiting whatever needs to be done, that they're not going to fear ICE, other than if they get arrested, they're going to be treated that way. Because you've got an image issue. And as a member of Congress, I don't want you to have an image issue because you have a mission. And that mission is based on the laws that we have passed. But you got to work on this. Do you have any type of, and this is my last question because my time's out now. Do you have any type of program trying to work on your image now that, whether you believe it or not, is not good for 50% of this country?
I would love the media to publish all the tremendous things that we do. And we try diligently to get our story out there. Unfortunately, it's not sensational to say ICE did a good job and removed this aggravated felon, or ICE removed this murderer back to El Salvador where he'll face charges, or ICE seized, 1,000 pounds of fentanyl, or ICE rescued this child from active sexual exploitation. Those stories don't get picked up, and I can do as many TV shows as I want, and a lot of it just falls on deaf ears, unfortunately. And I think that's where we were going to earlier, with just the rhetoric is so high on this issue.
I just had 30 seconds. I want to lead into Mr. Price. It's just two numbers. Two numbers. I want to point out one concern. The amount of arrests for traffic is 26,000, traffic offense 30,000. That seems to be the highest numbers. That's part of our issue. Mr. Price is going to deal with that. Go back.
Thank you, Madam Chair.
Numbers.
So Director, do you or your officers get to decide who will actually be deported out of custody?
Again, unless the individual already has had their day in immigration court and has received a final order of removal from an immigration judge, we are the front end of that process, just as a local beat cop or a detective is in the criminal justice system. We are making the arrest based on probable cause and are filing our charging document, which in our case is called a notice to appear, as opposed to a criminal complaint filed by a local jurisdiction.
But your men and women make no deportation decision, correct?
Correct. We make the arrest. The judge makes a determination with regard to, in limited circumstances, there are some cases in which individuals under the law are not entitled to a hearing with regard to the removability issues,
right,
but they are entitled to a hearing with regard to asylum or other form of relief from removal.
Right. And the reason I ask, and I think you said it earlier, you don't get to pick and choose what laws you're going to enforce. And so one of the things that I think people need to understand, and it really kind of came up on the military issue. Your officers, when they go to a 287G facility and pick up an individual on a detainer, that individual's been charged. You don't have a choice. You pick them up. Whether they have military service in their background or not, and how that will impact on their individual case is really up to the judge, not you or your officers. Is that correct?
That's correct. The judge makes a decision on removability.
Okay, so let me change gears here. While there was a decrease in the number of migrants that were crossing the border in June relative to May, we still have over 100,000 people that cross the border. We're still hearing about the metering going on at the ports. CBP detention facilities are still over capacity. You just received $208.9 million in the supplemental bill, and so my question today is: Do you anticipate that will get you through the end of the year? That's going to be enough, or what's the burn rate on that?
So the money that we were given, and we are appreciative of it, is for the areas in transportation, medical services, the money that we were able to give to HSI to go down and do additional family fraud investigations and DNA testing, which has proven very successful. That money is greatly appreciative and went right to work. Unfortunately, from a detention perspective, we're still short, and we're also still short a little bit in the transportation area. So, I mean, our request in the supplemental was around $110 million, and that need still remains.
Right. I tried to move $600 million over to you guys from forfeiture and seizures to address the detention beds, and that failed. But let me ask this also. After a successful pilot in May, you mentioned the rapid DNA processing. that ICE, you all awarded a $5.2 million contract for additional DNA testing and supplies. Can you give me an idea how that program's going, the rollout? How's it looking?
It's looking, when I say it's looking good, I mean that from an operational perspective. From a criminal justice and victimization perspective, it's looking bad because we ran the first week of it. Last week, we've opened up in 7 different Border Patrol facilities. We've got 2 machines in each facility with more machines to come. And within the first week, there were 102 referrals to us. We found 17 instances of fraud based on the DNA test. And in fact, this is an experience we saw when we ran the pilot as well. 14 of the individuals broke to the fact that they weren't really family units to begin with at all before they even took the DNA test because they saw that that was a potential for them. So we're continuing to pursue that as that rolls out and we add additional machines and capability. I'm sure the results will go up significantly. And I'm hopeful that there's some deterrent effect with that as well because the word spreads.
Yeah, yeah. And how many family groups have you discovered through that where it's not a parent, but it's an aunt, an uncle, that sort of thing?
So we've got a couple things going on at one time. We've had about, if you look at just the family fraud investigations that have been going on in the surge that we've got down there that's going on for several months, we're only getting the cases that Border Patrol refers it to us, so we've had about 3,000 cases referred to us. Through the investigative process, we found about 400 of those to be fraudulent. Most of them, there are some that are family members. Usually what happens, but when we're saying that they're fraudulent, they're presenting themselves as if they actually are father and son or mother and son, whatever the case may be. Or what we're finding a lot of them is that they're actually adults. So you've got an uncle that's 32 years old and you've got a kid that's 19 years old and he comes in and says, this is my 17-year-old kid, release this as a family unit. So we've actually presented 790 prosecutions during this time and 682 have been accepted for prosecution. What we're also seeing, which is very troubling to us and we're doing our best to combat it, is a lot of the individuals claiming to be UACs aren't UACs. We're finding individuals that are 23, 24 years old coming up with 16-year-old or 17-year-old birth certificates. We're extremely concerned about that because those individuals are going to go into HHS custody. And the last thing we want is a 24-year-old male being in custody with a bunch of 10-year-old boys. That is an untenable situation for all concerned. You know, our overarching goal, as we've said all along, is to keep the safety of these children. And so we've identified 59 of those, 58 of those have been prosecuted. The U.S. Attorney's offices down on the southwest border has been a tremendous partner for us.
Thank you for your service. Madam Chair, I yield back.
Mr. Aguilar.
Thank you, Madam Chair. Thank you, Mr. Director. On Tuesday this week, you told reporters that the reason ICE raids were successful is because the agency had the element of surprise. You also said that when media attention is drawn to potential ICE raids, it inhibits the ability of ICE agents to do their job. Is that fair summary?
I'm not sure I said we had the element of surprise with all the media attention that got, but I'm not sure the exact quote, but
typically when congressional offices ask for additional information about rumored raids, ICE frequently tells us that information can't be shared because of pending operations. You know that that's generally a response that we receive, correct?
The only thing that is correct, except for the fact that I think it's a disservice to classify them as raids. We were going after targeted individuals who had been through the immigration court process, who we know who they were, and have been issued a removal order from an immigration judge. So I think doing a raid, again, I think calling them that heightens the temperature with all these issues, as opposed to just when the sheriffs go out or a police department goes out and executes a warrant on somebody that has a warrant, they don't call it a raid. They say, we're going to go arrest this guy. That's what we're doing.
Sure, and in some cases, there's quite a bit of collateral arrests that are made as well, and I think that's where, in my interpretation, and that's my feeling, and we can get into a whole conversation about trust within the agency, and I think that, you know, you've talked a lot, and I know that that's a point of frustration at times for folks about that relationship with the community, but I think that comes with trust. And when the collateral numbers, you know, increase and vary pretty significantly by field offices even, you know, that's a concern for us. That's a concern as a policymaker, and that's, I think, when you get into a classification and what I would call a raid is when there are significant collateral arrests that are made. If you want to go in and target someone and you can highlight the criminality, you know, that's fine. But when you get into the collateral pieces and you start, grabbing other folks who are in proximity and breaking windows, pulling people out of cars, those are things that heighten the level, and I just want to make sure that you understand that that's what we're talking about.
I certainly do, and collateral arrests have occurred throughout the time of immigration enforcement, and they occur in law enforcement. Our law enforcement practices are the same as state and local law enforcement agencies. When they go in to a residence and they have a warrant and they are going to identify for their safety as well as the safety of the participant, or excuse me, the residents of that house, they're going to identify those individuals. And they're also going to try to determine if those individuals have wants or warrants, or if that individual, maybe they have a gun on them, is committing a crime in their presence, they're going to arrest them. When I was with DEA, almost every time we went into a house and arrested the target of our warrant, there was somebody else or many somebody else's that also ended up being arrested. It's the same thing when we go into a residence. We go in for officer safety and ensure that we know who's in that house. The last thing we want is a tragedy, to have somebody jump out of a closet and scare one of our officers or
someone with orders of removal is not the same as a drug dealer that you're getting at the DEA. I would just reject that comparison. But let me move on, because I just wanted to have that conversation about the announcements of targeted enforcement, I'll call them. You don't want to call them raids. So do announcements of ICE enforcement actions impact officer safety and effectiveness?
What we try to do is ensure that when we go out and do our operations, we have as much operational security as possible. When we go out to knock on a door or take an enforcement action, we generally notify local law enforcement to make sure we don't have a blue-on-blue situation. So we make sure that there's information that the people in the community that would be in a position to need to know do know.
But the fewer people that know, generally the more effective and probably the better for officer safety. Is that fair to say?
Again, it depends if you're talking specifics or talking in generalities. If there's specifics, like when our operational plan was leaked to the media and there were specifics, that's disconcerting, yes.
Sure, the president announced on multiple occasions that large-scale operations were going to detain undocumented immigrants, and as part of Operation Border Resolve, did you know that the department or that the president was going to announce those pending operations?
No, I don't believe they reached out to us for our input.
Do you think it put officers' safety in danger?
I don't. Again, when you start, the Washington Post was reporting on this in the fall. Again, when you talk about high level that we're going to be doing X, Y, and Z without specifics, I think everybody knows we're going to be doing immigration enforcement. We generally take, in a civil immigration context, 300 to 400 arrests a day. So our teams are out there every single day. So it's no secret that we're out there.
Yeah, it's no secret you're out there. I think the president putting millions behind it and amps it up, quite significantly. So I would just caution if I hear you talk about the rhetoric of this conversation. Well, I don't think that's limited to members of Congress is all I would offer. Thank you, sir.
Mr. Cuellar.
Thank you, Madam Chair. Mr. Director, I know we've been talking a lot about immigration, but I also want to thank your men and women that do work on the other cross-border criminal activity, which includes financial crimes, money laundering, bulk cash smuggling, commercial fraud, intellectual property theft, cyber crimes, human rights violation, human smuggling, human trafficking, and other work that y'all do. So I do want to thank them for the other work that they do, even though we do spend a lot of time on immigration. The other thing is, I feel that if you go to some other countries, they have their immigration courts at the border. Your folks have been a little resistant trying to put those courts at the border, I can tell you. They'll give me all this different excuses why, but I think we ought to hold people at the border, give them their day in court, give them their due process. And as you know, according to the Immigration Court Office, if you have 100 people, 88% of them are going to be rejected from asylum claims, and then 12 of them are going to be accepted. But unfortunately, we let people into the country, and they're here for 2, 3, 4, 5 years, whatever it is. Immigration courts also tell us that 44% of them don't show up after they're given the permiso, the notice to appear. So I think we're doing it backwards. I think the Trump administration, the Obama administration have been doing it backwards, so we should have them there. So I would ask you to have your folks reconsider the positions that they've taken in the past where we have those immigration courts as much as possible. When we talk about immigration courts, and we've added, I think, about 315 since we started working on it, I guess since 2014, first thing they do is say, well, we want to do video conference. Well, as you know, the reason they send judges to Houston, to New York, San Francisco, and all that is because they release people, and then they want to put judges where the people have been released. So I think we're doing it backwards. But I would appreciate that and like to follow up. The other thing is we have been adding judges, and I think that your office of principal legal advisors needs a little bit of help. I believe your information is you probably need another 128 additional attorneys and 41 additional support staff so the immigration judges can do the work. I think what we're missing right now are court space. We actually have more judges than court, and we're hoping that during this appropriation process, working through another subcommittee, that we add court space, number one. Number two, that we add those attorneys, because if you don't have those attorneys, it's hard for the judges to do the work. I would ask you also, because I do know a lot of immigration judges, that y'all look at the old show called Night Court, or Night Court. I do understand that your attorneys leave at 5 o'clock or so, from what I've heard from judges, or somewhere 5, 6 o'clock. And in many ways, we ought to look at that show, and if we need to do a little bit of extra work, we should have some sort of night shift to address the backlog. So anyway, we want to be supportive on adding more monies on that, and like to get your thoughts on what I just mentioned.
No, certainly, and I agree that trying to, look, we've got to be inventive. We can't keep doing the same thing the way we've been doing and expect something to change, right? I agree, and as you're seeing in the MPP context, where we're setting up these courts at the POEs and holding the hearings there. Again, I think we can leverage VTC for that, both for EOIR, and again, obviously they're the biggest player in this, right? They own the courts, they own the management of the courts. So I mean, a lot of this falls on their shoulder, and we work closely with them, of course. But I think that holds promise. Again, the challenge comes into, especially now with so many of the family units being the largest number of cases coming in, right? That we can't hold them, we can't detain them for under Flores long enough to get through that immigration court process. So that's one of the bigger challenges. I will tell you that, when I testified when I was at EAD for ERO, and I'll say it again, I'll take 200 attorneys before I take 200 officers at this point, because the bottleneck is just there, the massive amount is there. I will get more productivity from those attorneys than I will from those officers, just because the work is there. And so we're working closely with EOIR to try to find some ways to do some of these things if we can leverage technology. We have opened up courtrooms in some of our new facilities so that we can move those cases through more rapidly. But this is one of the ones where, again, it's resource dependent, and you're right. It's not just attorneys; it's courtrooms and facilities and support staff and the like. And we'll take whatever we can get plus some. Thank you,
Mr. Price.
Thank you, Madam Chairman. Mr. Director, let me just briefly revisit the statistics on whom you're detaining and deporting, mainly just to underscore my request, because I want to move on to another question. But I've been looking at some figures about the breakdowns we were discussing. It appears that 3 of the top 4 categories in terms of people who are categorized as criminal convictions, three of those 4 categories are drug offenses, DUI, traffic offenses, DUI, traffic offenses more generally, and immigration offenses. Now, other crimes here are very serious, many of them violent. But as far as the numbers are concerned, I would just return to my prior assertion that, an overall 90% figure really is not helpful. The appearance is that it's obscuring the discussion more than it's helping with it, given the fact that the discussion has been and needs to be on prioritizing dangerous people who are a threat to the community. I appreciate your comments about the way the diversion of personnel from the interior to the border surge has compromised your abilities. On the face of it, though, it doesn't seem to me that would affect the ratio of. It might affect yes, it affects the overall number who you detain and deport. It shouldn't affect the overall ratio of dangerous criminals to others. So if there's any figures on that would clarify the situation further, I would appreciate it. But we certainly need a breakdown of that 90%. Now let me turn to the something that's been in the headlines in my own district, but that it just puzzles me nationwide, and I want you to comment on it. There, of course, is a very often very difficult situation involving people who are taking sanctuary in places of worship. But how are you putting pressure on those immigrants and those who are supporting them? That's the question. And there's a recent case, a 38-year-old mother of 4 taking sanctuary in the Church of Reconciliation in Chapel Hill in my district. One of 5 individuals taking sanctuary in a church in North Carolina. One of at least 50 across the country. Now, just out of the blue, July 1, she received a notice that ICE intends to fine her $314,007 for, quote, willfully failing or refusing to leave the United States and for having, quote, connived or conspired to avoid deportation. That amounts to $799 a day for each day that she's been in sanctuary. Now, apparently she's one of fewer than 10 undocumented immigrants living in sanctuary who receive this notion of a fine for this just impossibly high sum they can't possibly pay. It's my understanding the financial penalties for violating immigration laws, of course, do exist. They've existed since the mid-90s. But it's very rare that they have gone above about $1,000. So what's this all about? Why is ICE now using these extremely severe financial penalties to target this group of individuals? How did you determine that it should be $799 a day? Actually, the law states that civil penalties for immigrants should be something like $500. Yes, it states not more than $500 a day. What's going on with these fines, and how are you choosing whom to impose them on?
Thank you. So we've been looking at this, and again, what we're trying to do is hold individuals accountable and try to restore some integrity to the rule of law and the immigration system. If you have individuals, again, and we are applying the laws that Congress has passed and authorized us to do. They have authorized that civil fines be levied on certain offenses or certain behavior. One includes a fine for an individual to ignore a voluntary departure ordered by an immigration judge. There's a fine that comes with that. There's a fine for failure to depart for individuals with final orders of removal. And there are very strict criteria that must be met in order for that to happen. And one of those is the order was issued in person. So it wasn't even that the individual can't say they didn't know they had the order. It has to be an in-person order, which is essential. The $799, and we did a Federal Register notice on this last year when we began the process, is accounted for inflation, and that's how it came to that amount. But if we're going to have any integrity of the immigration system, I don't think we can have a system whereby somebody can avail themselves of all due process, work the system for 5, 6, 7, 8 years, and then when they get a result that they don't agree with, go take sanctuary in a church where they know our sensitive locations policy prevents them from having the law enforced against them. So we are going to use all the tools available to try to gain compliance with the lawfully issued judge's order. And part of this, too, is if we want to have a secure border, there has to be consequences for illegal entry. And that means that you have to leave the country if you're ordered removed by an immigration judge. And if you fail to leave the country and there's a way that we can fine you civilly, then we're going to do that too.
You think there's any doubt these people have that you're on their case?
Now.
I mean, why are you doing this now? Why are you doing this now? How did you pick the 10 people around the country that you were gonna slap these fines on?
So we've been doing it I'll be off a month or two, maybe October of last year, we started this process. We've been going through each of the field offices, and again, there's very defined criteria which an individual has to meet in order to be eligible for a fine. So it actually takes quite a while to review the case to determine if they meet all the factors required by law and statute to be amenable to being fined. So we've been going through various field offices. They're going through their cases of fugitives and individuals who've avoided orders of voluntary departure, trying to find individuals that are there. And some of the individuals, when we located them, we arrested them and removed them rather than finding them because we knew where they were and able to locate them. But individuals that we can't locate or are unable to find or that take sanctuary, I mean, put it this way, there's more sanctuary cases out there than those that were fined. It's the other ones that we reviewed didn't meet the legal criteria for a fine.
Well, if you could, for the record, furnish what those legal criteria amount to.
Certainly, we have it all written out. Certainly get that to you.
Certainly a mystery to me and to my community. Thank you, Madam Chairman.
We are past the time and I appreciate your agreeing to stay here beyond the 3 o'clock schedule that we had originally given you. I do have some other questions that I will submit, particularly with regards to the treatment of pregnant women in detention that I'll be following up. But thank you very much for your time, and look forward to continuing to work with you on some of the issues that have been raised.
As do I. Thank you.
Thank you.